Hi, thanks for watching. Okay, so today, June 1st, okay, it looks as though Chad Daybell is getting the death penalty. He's getting a death sentence. But the reason I'm doing this video, okay, is because there is something very unusual about these death proceedings, about this death penalty proceeding, okay? I'm sure many of you noticed that Chad's defense team and Chad himself waived their mitigation arguments, okay?
The court has been advised by defense counsel of an intent to potentially not present mitigation.
They actually waived their right to present mitigation arguments in the death penalty phase, okay? And Chad also waived his right to allocution.
Mr. Daybell, the purpose of these rights is to potentially present evidence to the jury that could result in them finding that the death penalty should not be imposed in your case. Do you understand that?
I do.
All right. And I'm also advised then that you do not intend to, despite the preparation of mitigation from your attorney, you don't intend to present that evidence at this hearing. Is that your choice?
That is my choice.
Has anyone coerced or pressured you personally to make that choice?
No.
And do you feel like you're thinking clearly this morning as you make that choice?
Yes.
Okay, so let's just kind of parse that for a second. Now, I've seen some legal commentators on YouTube sort of trying to react and trying to interpret why Chad would waive his mitigation arguments, right? And so far, I haven't heard like a real solid interpretation of why this may be a strategy. Okay, and I don't know for sure, but I'm going to offer you what I think is very likely the strategy here. Okay, and this doesn't make any sense if we don't go back to the January hearing on John Pryor's so-called motion to withdraw. And I'll explain why it wasn't really a motion to withdraw. But let's go back to a very key aspect of that hearing back in January where Judge Boyce was anticipating this issue of the mitigation. And we'll see something very telling here.
Of course, this is a capital case, and if there's a conviction in the case, then generally that requires, for example, the appointment of a mitigation specialist for the defense team. And I'm not asking you to reveal any defense strategy or even list a name.
And from my experience doing consulting and criminal defense work, okay, I can tell that Judge Boyce is kind of nervous because he says, oh, and I don't want you to reveal your defense strategy. It's like his way of saying he knows there's some kind of strategy going on here.
And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Okay, this is very important. Okay, and how John Pryor responds to this question is very important. And you'll see that this was all kind of planned out. Okay. And you can also see that Judge Boyce, he knew he was in hot water. Judge Boyce knew he had a problem as a judge because really in death penalty cases, you never really see private counsel, okay? Very rare. Like say in the Scott Peterson case, Scott Peterson had $1 million defense team with attorney Mark Garagos, right? But there's nothing on that scale going on Chad's side. Okay, so Judge Boyce was probably very concerned that there wasn't actual a mitigation defense being put up. All right, but let's see how John Pryor responds, and this is the answer.
If the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy.
Okay, so now we know for sure, we're dealing with a trial strategy. Okay, no doubt, it is a strategy.
But at this point, I am not prepared to make an open statement on live TV about what my strategy is.
Okay, so now we know this was discussed with Judge Boyce back in January.
If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this.
And you'll hear later that they even had an ex parte meeting where the defense team met alone with Judge Boyce, where even the state wasn't involved.
The court conducted a closed portion of the proceedings to make further inquiry, and then in addition conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel.
Okay, so we do know there's a strategy. We do know that Judge Boyce knows about it, okay? But the thing is, it's not public. The public doesn't know about it, so all we can do is kind of guess, but I think we can figure it out, okay? I think the key to it is to understand how the January hearing on John Pryor's supposed motion to withdraw, how that wasn't really a motion to withdraw.
I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw.
Okay, I think that's where we're going to get the answer. And actually, it's not even that interesting, really. It's just something I think the defense wants to keep in their pocket.
Judge, I appreciate the court releasing the order from 8/25/23.
So John Pryor is suggesting in this motion to withdraw, he's suggesting that what he's really interested in is the court's ruling of August 25th. Okay, and what was that ruling on?
The court's well aware, ex parte, that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him.
Okay, so this is the problem. Okay, it wasn't really a motion to withdraw. Okay, setting up the motion to withdraw was just calling more attention to an earlier ruling that Judge Boyce made back in August. Okay, and what happened was back in January, way back the earlier January, okay, John Pryor had filed a motion saying, look, Chad Daybell wants to keep me as private counsel, but he also wants additional counsel to be supplied by the public defender system of Idaho, right? And here's what happened. There's a statute in Idaho, right? And the Idaho statute, basically the way they read it is that if you elect to have private counsel, then you don't have available those public defender funds for indigent people, right?
And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys.
Okay, so Lindsay Blake is arguing that Chad basically forfeited. He waived his right to have like public defenders appointed into his defense, right? But here's the thing: Lindsay Blake is interpreting that from a statute. Okay, Chad never said he's waiving his right to have public defenders. Chad said he wants Pryor. And what Lindsay is saying is that through the application of a statute, Chad was effectively waiving his right to public defenders, right?
He opted to stick with Mr. Pryor.
And so it's a question of how Judge Boyce applied a statute, right?
And I'm relying on the court's interpretation of that statute.
Okay, so now we can see what's happening. Okay, the question is not about whether Pryor should really withdraw. That was just kind of a sham proceeding. He's just calling attention to an earlier ruling by the judge.
It's the only mechanism I can think of to allow Mr. Daybell to get two capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
And I think I know what they're up to. Okay, this is it. This is what the defense is up to. I think they're trying to set up an appeal. They're trying to set up an appeal, not that Judge Boyce made a mistake so much. I think they're setting up an appeal that the Idaho law is unconstitutional. Specifically, the part of the Idaho law that says that if you elect to have the counsel of your choice, okay, if you elect the counsel of your choice, then you're cut off from the public defender funds, or I shouldn't say the funds, because there probably could be ways to get him some money if he wanted to find some extra lawyers. But I think cutting him off from the mechanism in Idaho law where you get either a public defender or a court-appointed expert attorney, someone who's death qualified, right? So basically, this law, this statute, okay, that gives you kind of this either or. I think they've done their research. I think that John Pryor and Chad, I think they have other lawyers like in the shadows, maybe some appellate experts that have done the research. And I think they really believe the Idaho law is unconstitutional, right? And it doesn't surprise me because really it's very unusual to have private counsel in death penalty cases. So the legal system in the United States is not really set up for, like, say, a hybrid defense where you have some private and you have some public defenders or some court-appointed counsel. The system is not really set up for a hybrid defense because it doesn't happen very often. So they found a chink or a weakness in the legal system.
And under our current law and the way the law is written and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the two attorneys that he wants, the only way to do that is for me to make the decision to step away from this thing.
So you see there how Pryor, he's not so much accusing Judge Boyce for making a mistake. Okay, he's saying that Judge Boyce probably had no choice because he was following the law as written, the legal system as it stands. Okay, obviously John Pryor is criticizing the current legal system, and that is the hint that that's his big appeal. Okay, he's not going to have an appeal saying, oh, Judge Boyce made all these mistakes. I mean, he may have that, but the appeal that he's hiding and he doesn't want to make public, Okay, because if he makes it public, then the Idaho Attorney General's office is going to go crazy researching, and they'll maybe even try to change it. Who knows? But he's trying to keep it kind of secret. Basically, the idea that he wants to challenge the legal system of Idaho. Sorry, he wants to challenge the death penalty, public defender assignment statute, the statute that allows people to get either public defenders or court-appointed death qualified counsel. He wants to challenge that statute as being unconstitutional.
But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
So how would this Idaho statute actually be unconstitutional? Okay, what would make it unconstitutional? Okay, to understand that, you have to go to the 6th Amendment of the Constitution and the 14th Amendment. Okay, the 6th Amendment is basically a cluster of rights that have to do with being able to get assistance or being able to have access to an attorney to defend you. Okay, basically the Constitution basically provides people with the right to counsel, even if they're indigent, right? So you could say that the 6th Amendment allows indigent people the right to counsel, but the 6th Amendment has also been interpreted as allowing people the right to counsel of their choice. Okay, so both of those rights are inherent in the 6th Amendment. So basically, you got two competing interests. You got the right to indigent counsel, meaning the right to counsel if you can't afford it, the right to appointed counsel, and then you have the right to counsel of your choice. But what happens when you create a statute that puts those in conflict? Where if you get, let's say, if you're given the right to counsel of your choice, that actually conflicts with and it cuts out your right to indigent counsel, your right to counsel, appointed counsel, right? So it's like the right to appointed counsel is now competing with the right to have counsel of your choice. And I think they're going to say that that's unconstitutional to have a statute that puts two aspects of the 6th Amendment at odds with each other. Now, I understand anybody who knows constitutional law really well knows that the right to counsel of your choice is a limited right. It's not a full blown 100%, and it can give way to other aspects of the 6th Amendment. I understand that. But I think what they're going to say by the 14th Amendment, the Equal Protection Clause of the 14th Amendment, I think they're going to say that the statute as written and as applied basically deprives certain people of rights that other people in the state would get. So Chad's going to say he's treated unequally compared to other similarly situated defendants in Idaho, or just in general, he's treated unequally from other defendants in Idaho just because he made a decision to have access to his 6th Amendment right to counsel of his choice. Okay, so it may sound kind of confusing, but basically they're going to argue that when you put the 14th and the 6th Amendment together, this statute creates a situation where Chad is not treated the same as other defendants in a more or less similar situation, with the only difference being that he's actually availed himself of the constitutional right to counsel of his choice. So basically, it's sort of pitting these two aspects of the 6th Amendment sort of at odds with each other in a way that would violate, I think, the 14th Amendment. And I think they've had someone research this, and I think they think it's a pretty good appeal. But the real question here, and the reason for this video, the reason I'm doing this video, is why would it be a good strategy, and why would Pryor want to kind of hide it and keep it out of the public view, but why would it be a good strategy for Chad to waive his mitigation in the sentencing phase? Okay, and why would it be a good strategy for Chad almost to let himself get the death penalty? Okay, why would that be a good strategy for Chad to almost let himself get the death penalty? Okay, and this is one of the reasons why I think that Pryor is probably a little bit better lawyer than what we think. Number one, I don't think he's great. He's not a great lawyer, but I think he's better than what we think. And it's also why I think they must have some appellate team in the background. They got some underground attorneys doing appellate work that are basically, giving Pryor a lot of assistance, okay, that we don't know about. But I think what John Pryor probably told Judge Boyce when they went into private meeting, okay, remember back in January, they had a private meeting where I don't even think the prosecutors were allowed in, or maybe he said it in front of the prosecutors, but in private, John Pryor probably told the judge, hey, look, judge, we do not agree with the statute, okay? We don't agree with that statute that forced you. The statute that forced you to keep us from getting a couple of extra death qualified attorneys appointed into our team. Okay, so it's nothing against you, Judge Boyce. You had to do what you had to do because you read the statute the way it's written, right? But we're just letting you know that we disagree with that statute, and we're setting up, and we don't want to talk about it publicly, but we're setting up an appeal because we think that's unconstitutional, right? And so basically what he probably told Boyce was that if Chad allocutes and if he presents mitigation, that's his way, in a way, kind of suggesting he doesn't really feel he's been injured by your decision, right? And so in order for Chad to preserve his appellate position, okay, in order for him not to look like he's going back on his appellate position, okay, he doesn't want to acknowledge the legitimacy, okay, of a ruling that, based on this statute that has him going forward without more death qualified attorneys, okay, paid for by the state of Idaho, just like Brian Koberger has up there in Moscow, Idaho, right? So basically what John Pryor probably said is that, he thinks it's a better strategy not to allocute and not to present any mitigation, because that in a way would be a way for my client to sort of acknowledge that it's okay what's been ruled by this court, when in reality, he takes a strong position that he disagrees with this court's ruling. And the court obviously had its hands tied because it was just reading the statute the way it is. But because we have this appeal, my client feels it would be more consistent for him not to do anything to acknowledge the validity or not to do anything to acknowledge the correctness of an earlier ruling that the defense disagrees with. But I don't think that's the real reason they did it. That's the reason they told Judge Boyce. You see, when you're a lawyer, you have to learn all this doublespeak. You tell the lawyer one thing to make yourself look good, but then in reality, you're doing something else. Because here's the thing: if they told Judge Boyce that my client would rather get a death sentence, right, because he'll get more appellate resources and more funding, okay, then that looks like invited error. You can't have invited error in a legal proceeding. You can't appeal something that you invited the problem, right? So they had to tell the judge something that sounded pretty good, but really I think what's going on is they think it's much better for Chad and much safer for Chad to be on death row. Death row, I think there's only like 8 people or 7 or 8 males on death row in Idaho. It's less than 10 people, I think, on death row. If I'm wrong about that, it's like around 10 people. I think it's less than 10 people. It's a very safe, controlled environment. It's a much, much better than Chad going into general population. And here's the thing: if you get on death row, you have way more appellate resources. You have access to literally millions of dollars of appellate resources and fantastic appellate, not just direct appeals, but also collateral review, through all the habeas and federal habeas. The other thing, finally, just to close this, is that when you do have a death penalty case, okay, the appellate courts take it way more seriously. So looking at it from that strategic position, okay, if they're going to float this fancy constitutional law appeal, it's going to look much better if he's on death row, because that makes the appeal is taken as more important by the appellate court. The appellate court takes those appeals way more seriously, much higher chance of going to the Idaho Supreme Court and possibly even to the US Supreme Court if it really runs into a major constitutional question. So basically, Chad will hit the gold mine of appellate resources if he gets the death penalty. So now you can't tell that to the judge. So they probably told the judge, well, my client doesn't want to take a position that's inconsistent, and because that might be taken as him not really preserving his appellate argument, whatever. Okay, fine. But I think what they're really doing is I think they'd really rather see Chad on death row because they know it's a safer place to be. Okay, let's just remember, in Idaho, nobody gets executed. Chad will, number one, he won't get executed, A, because it's Idaho, B, because he actually has a pretty good, I don't want to sound like I'm supporting Chad. I really don't support him. I'm saying just thinking clearly, he probably does have a pretty good appellate question. And this is very, very similar to the Scott Peterson case, where Scott Peterson had the strawberry shortcake juror. Remember the strawberry shortcake, where she said something a little dishonest in some jury questionnaire? This, I think, is the strawberry shortcake. I think it's this Idaho statute that cuts into Chad's Sixth Amendment right to counsel of choice versus counsel appointed, for indigent status. Okay. And I think they really feel like that's their strawberry shortcake, that they'll be patient. They'll mount $1 million appeal paid for by the state of Idaho, right? Idaho will pay for this appeal if Chad goes to death row. So they'd rather be on death row, where he's going to be safer. He's not going to be in general population, and he'll have huge gold mine resources, okay, for a first class appeal. He'll get a really good appeal, and they think that's a better way to go. But you can't say all that to Judge Boyce, but I think that kind of explains what's going on here. And so I think they feel like this is like the best place for Chad strategically, considering he's in a state where people don't really get executed. So anyway, appreciate your patience, and I really appreciate your patience. I know these are long videos, but thanks for watching.